Welcome back, everyone. I'm DC the Blacksmith, and this is going to be my recap and review for day 3 and 4 of Ketanji Brown Jackson's Supreme Court confirmation hearing with the Senate Judiciary. So hopefully I can knock out day 3 and 4 in the same video, and I'll figure out how to put a timestamp in the middle. So day 3 was the 20-minute round questions. And remember, on my last recap, I included a little bit of day 3 because they didn't finish their 30-minute rounds, and they let 2 of the senators do their 30-minute round questions on the 20-minute round day. It, doesn't, in the grand scheme of things, it doesn't really matter, but I like to explain the process because not everybody has time to sit and watch hours and hours of Supreme Court confirmation hearings to know what process it is. But so starting with day 3, the 20-minute rounds, Dick Durbin, Democrat, opens up and he wants to provide some clarity about the brief where they allege that Ketanji Brown Jackson put in the brief calling former President Bush and Secretary of Defense Rumsfeld war criminals. I think I explained that in my last video, but he reiterates that it's boilerplate language from the defendant, from the person who obviously is being detained and doesn't want to be detained, and he's putting that in. And then he also points out that they were named in their political official capacity, not as people. So later, when the administration changed to the Obama era, him and his person were named. It's not, I guess it's a big deal to some people, but that's how advocacy works. You get your client, you argue for your client, and typically, yeah, if you're defense counsel for someone who's been accused of being an enemy combatant, yeah, you're going to say that this is a war crime. Yeah, that's what you do. That's how you're going to get them out. That's what they're going to want you to say. I almost would say that if you don't say it, it might be bordering on not being as best of an advocate as you can. Some things you just automatically put in. So then Chuck Grassley speaks. He says that he supported enhanced sentencing. Remember, we were talking about the issue with her and those child, the sentencing issues. He asked her about her judicial philosophy again. She repeats that she doesn't have a judicial philosophy. She has more of a methodology because she comes from practice. She doesn't come from academia. So her method of how she approaches cases comes from actually practicing cases, not someone who just studies all day. And again, I don't want anyone to think that that's a dig at academia or attorneys who go into academia. Hey, that's a good job. That's a nice, cushy job. I wish I could just sit and study and learn and expand my mind all day and get paid for it. That is wonderful work. However, if you are a practicing attorney, you don't always sit down. And I'll tell you a story. So when I first came out of law school, I interviewed, obviously, with law firms, to be a law clerk, and hopefully that would lead into being an attorney for that firm. And one attorney that I interviewed with, we were having a good conversation in my interview, and I ended up asking kind of offhandedly what was her favorite practice area. She'd been practicing for a while, and she was like, oh, I have cases that I take more than others, but, we take what cases we need to take to pay the bills. You don't really get to pick your cases like that, because she was a practicing attorney. That's what's her job. She did. She took a variety of cases that came through the door. Whereas had I asked someone who maybe they came from academia, or maybe they had the opportunity to specialize in, one of the fancy federal cases, they might have had a different answer. Does that mean that she was any less of an attorney than anybody? Absolutely not. That just means that her area of practice, her role, so to speak, in the grand scheme of the legal profession was different. So yeah, I actually wouldn't expect Ketanji Brown Jackson to have hammered down an ideology. And I suspect that perhaps um, after some time on the court, that maybe she might have a judicial philosophy, or maybe she might be able to translate her methodology into a philosophy, or maybe more lower judges might adopt a methodology instead of a judicial philosophy. One way is not the only way. So she brings, they have that exchange again, her and Grassley. Then he asked her, has she ever declined to enhance a sentence due to a policy disagreement? And she says absolutely she has, because the Supreme Court, in a decision written by Antonin Scalia, said that judges have sentencing discretion and they use the exact language as a policy matter. So yeah, she has. That's what she could do. She did what was in the bounds of the law. Now, if you like it, that was the law. She was able to do that. She heard the case, you didn't. So then he asked her about nationwide injunctions. And again, this came out of one of her APA cases. I think I explained last time that APA is the Administrative Procedures Act. Not all cases actually get into what the policy issue is. I'll give you a quick, very simplistic example. You can have a criminal case where someone was accused of XYZ crime. When you go to court, or if you're a defense attorney and you find out that your client wasn't Mirandized, there was no search warrant, so your client's fundamental rights, their Fourth Amendment due process rights were violated, you're going to argue that first before we even get into the merits of the case. And a lot of times, before we even get into what the crime was, if the police, if the warrant issuing judge or non-warranting issuing judge, in my fact pattern, in my hypothetical, did not follow the proper due process steps, the case gets thrown out. So it would be then unfair for someone to say, you let this criminal off because of this. No, processes are important. They're just as much a part of our Constitution as everything else. The criminal was let, or the alleged criminal was let off because steps weren't followed to even get to where we can argue about the crime. So it's not always a policy issue. A lot of things, I think when I was in law school, they told us that a lot of times most cases get thrown out on procedural issues. There's attorneys that specialize in civil procedure and criminal procedure, and they make a bit of money because you want the case to get thrown out on procedure before you get into anything else, before you get into any fact finding. But yeah, I think they told us most cases, they don't make it to the merits being the actual facts or the actual issue. Most cases get thrown out on procedure. So he asked her about forum shopping. Y'all, there are so many things built into the system to cut down on forum shopping that I didn't know this was still a that big of an issue. But maybe for larger corporations that do, with the internet, maybe more and more people are transactioning across state lines and across federal jurisdictions. So maybe I'm just ignorant to that fact, but I didn't go off too much into that. He talks about Grassley. We're still on Grassley. Ask about political question doctrine. Basically, the Supreme Court doesn't take up political questions. They take up cases and controversy, cases where there is an injury being alleged by an actual party. They don't take up, they leave politics or politics. And we're talking about Supreme Court judges. They've made it to that bench because they've achieved a certain status in the legal profession. I will point out that there is nowhere in the Constitution that says you have to be an attorney or a judge to be a Supreme Court justice. And I think in the past we have had, I guess as an attorney, I would call them lay people, be Supreme Court justices. Hey, not everybody has to take the same route to get to a destination, but when we're talking about Supreme Court justices, their name was picked because they've achieved something that puts them in the proper intellect and experience level to be able to parse these issues out, to be able to have these conversations. You know, I'd like to think that I'm a great attorney, but I probably don't have, just by way of experience or whatever, the tools necessary that some of these Supreme Court justices and nominees have. So the court knows what they're doing. Yes, do you have conservative leaning, maybe liberal leaning justices? Yeah. But these people are trained in logic. They're trained to give a logical argument to something. So, you know, I don't buy into the sky's falling, the sky's falling, the sky's falling. It's going to be okay. So then Senator Leahy, Democrat from Vermont, he speaks, he gets his turn. And he just points out that a lot of the people in that room know better than conflate representation of a client with someone's personal views. And that is true. Again, you'll notice the pattern on this same day, and I've repeated each day, the Republicans are going to ask more of the substantive policy questions. The Democrats are going to do more of the rehab, and, you know, they're not going to press her that much. They're going to give her a break. This happens the other way around when it's the Democrats, when it's the Republicans' pick. So that's not unusual. And to a certain extent, that's just what happens. I don't know if that's a good or a bad thing, but it's not unusual, and it's nothing to say, oh, can you believe they acted like this? Yeah, it happens on both sides. Again, in the exchange with Leahy, Ketanji Brown Jackson points out that the framers, they put into the Constitution the Sixth Amendment right to counsel. And I added in my notes, will the real originalists please stand up? If you're such an originalist, you want to, what the framers put, I don't know how plain can you get. Sixth Amendment, right to counsel in federal criminal trials. So you're such an originalist, but you're mad that someone helped another American, or maybe not American, maybe somebody in our court system, they helped them realize their Sixth Amendment right as written into the Constitution. What? No. But I bet you by then they'll make the argument, oh, well, that's an amendment. It wasn't part of the original text. Okay, now it's not part of the original text. Okay, whatever. So then Senator Graham talks. He, I thought Lindsey Graham had been normal for the other days, but I guess his donors called and told him that he needed to act. He needs to get real tough and loud because he did nothing but scream. And he said he wished that Janice Rogers Brown, an African-American conservative, had gotten the same treatment. That's fine. I think that's fair to point out. You know, this is also a time where they're going to use their time to give, speeches. They'll probably end up, on their, what do you call it, their campaign ads and things like that. Hey, it wouldn't be me. I would like, let me take that back. I would like to think that I would have more respect for the job that the constituents had voted me into than to use every opportunity for, lights, camera, action. I just really would like to think that if given the privilege, the honor, the responsibility of being elected to represent my district or whatever, my state or my locality, that I would not just do stuff for lights and cameras. I would be calm, and I would actually be a good steward of my responsibility. But maybe he feels that he is being a good steward. Maybe this is his way of being a good steward. But I do understand his point. Black and brown conservatives, women conservatives, they don't get the same deference in realizing that just like you have a brain, I have a brain. And my logical reasoning has led me to be positioned to align more so with this political ideology than this politically ideology that you align with. And you have a brain and it got you one way and it got me another way. And there's nothing wrong with that. Now, if you're speaking to somebody and they just don't make logical sense, and what I mean by logical sense is people who say, oh, my parents were like that, so I'm like that. That's not logic. That's not necessarily wrong, but that's not you hammering out these issues on your own. But I understood his point. I just wish that he had acted. But again, different people have different personalities. So I try to be judicious when I talk about people like that. He asked her about illegal immigrant voting, fetal pain and abortion, the Make the Road case. Again, he said, oh, she didn't make a decision because it was against the Trump. She said she followed legal reasoning, and I believe her. She explained her legal reasoning. When people can't explain their legal reasoning, that's when you start thinking that they just made decisions politically. But if somebody, whether they're a Democrat, Republican, left-leaning, right-leaning, up-leaning, down-leaning, if they can explain their legal reasoning, then they probably sincerely reasoned that logically. You don't have to like it, but we have several courts that appeal. It'll be fine. He talks about the sentencing, and she gives her same explanation about the discrepancy against at the time where the sentencings were written. We were talking about one piece, two pieces of images in the mail. Now we're talking about a click, tens of thousands of pieces. Yeah. I'm not going to go into that again because she's explained herself, and whether we like it or not, her explanation makes sense. It's not that she was just going around, oh, this isn't a serious crime. Oh, everybody can get off. That is not what she was doing. As a judge, she was making sense in her sentencing decision. So I'm not going to get off into that. Senator Lee from Utah, he goes, Republican from Utah. He talks about the APA cases, one out of West Virginia, one out of the DC circuit, I think is what he said. They had an exchange about a motion to dismiss. She didn't remember it. Most judges and attorneys don't remember. You know how many motion to dismisses you get? But he didn't stay on it or anything. She said she didn't remember, and he let it go. I will say, and I think I've pointed this out a few times, I don't remember, me personally, and I'm acutely aware of my Republican representatives in government. I don't remember Senator Lee ever really getting out of the way with people, like, talking aggressive or talking with a quote unquote attitude or anything like that. I've heard him disagree many times. I've heard him voice his objections many times. But even when he's given TV interviews, I just don't remember him acting or speaking in a manner that to me was unbecoming. So I have to point that out because I have a lot of respect for him. Ben Sass is another one that, typically acts like he got some sense. You give people their flowers, you build people up as well as critique them. So I just have to point that out. He discusses judicial interpretations. He appreciates her at least giving voice to original public meaning. He says he appreciates that she even considers that that's a thing. And I think that was very fair of him. And I know I give originalists and textualists a hard time sometimes, but some of them take it too far. But I think by her coming from practice and not academia, she's allowed to give nods to a bunch of different quote unquote judicial philosophies, if you want to call them that. And I think it's good that she does give a nod to what is mostly considered originalism. He talks about a very gruesome abortion case about the unaliving outside of the womb, and she doesn't, she said that's a political question, and I think Amy Coney Barrett was asked not the same gruesome, detailed question, but she didn't get into that. But yeah, she didn't get into the specifics of that, and I wouldn't have either. And I suspect that, he has time to speak on camera, and that was something that's important to him and maybe his constituents, and so he chose to get that soundbite in. Whatever, they all do it. It's no difference between the Democrats when they go down her resume when they get an opportunity to speak. Whatever. Then Senator Klobuchar, Democrat from Minnesota, she talks about the shadow docket. I maybe wasn't familiar with that term, or maybe I wasn't familiar with the practice and then the label that the practice has of the Supreme Court. So I'll have to do a little bit more research into shadow docket, because I think it comes up a few more times. I'll have to do a little bit more research and fully understand what the shadow docket is. But basically, she says that a lot of cases aren't decided. These aren't cases that hear oral arguments. These are cases that are decided with the briefs that come before the Supreme Court, and then it's a per curiam opinion. That means that it's an unsigned opinion. Nobody in particular want to put their name to it. A cop out is what it is. They can all put their name on it if they want to, but nobody puts your name to it. A cop out, but it happens. So then she just mentions that Ketanji Brown Jackson hasn't been allowed to fully contextualize her past cases, because a case, particularly a criminal case, just has so much in the record. There's so much. There's briefs, there's victim statements, there's family, there's impact statements from family of victims, there's statements from the family of the accused, there's statements from the prosecution, probation officers, there might be statements from the guards in the prison. There's just so much in the facts. There might be statements from the judge at the bond hearing, and that might not necessarily be the same judge that actually tries the case. They might have changed prosecution a few times, representation a few times. When you deal with a criminal case, there is so much in the record. And so the judge considers all of that, and then makes a decision. So she points that out. Then Senator Cruz goes, and y'all know that it was TV time. It was a lights, camera, action. I mean, he just really just showed out. Didn't let her answer. He talked about Article 3, cases and controversy. He asked her about a Harvard case coming up in which she recused herself. She actually, quite frankly, said that she had planned to accuse herself in that case. A Harvard case about discrimination against Asians. And he said, well, I wouldn't be able to sue because I'm not Asian. You would have to be Asian to sue. And she says, no, you would have to have an actual injury. And he says, no, but if I'm not Asian, I haven't been injured. That's not necessarily true. If the lawsuit is about discrimination against Asian Americans, you don't necessarily have to be Asian to have an actual injury in that case. Just in a hypothetical, I can think of maybe there's a particular Asian American organization that donates money to Harvard in anticipation of Asian American students. And so maybe their money's been rerouted because of, maybe there's not as many Asian American students, and so there's a surplus in money. And then they might go in and say, well, there's not as many Asian American students because of discrimination practices. I think that would be an actual injury. And that group may not necessarily be comprised of Asian Americans. It could be comprised of any type of Americans who just want more Asian American representation you know, as a form of allyship. So the group also wouldn't have a demographic label. So I can think of many reasons that a plaintiff wouldn't necessarily have to be Asian American in that case. You have to prove an actual injury. You have to prove that you have an actual, that this impacts you in some real way. And then he goes on, Ted Cruz does, to talk about, well, people change their gender all the time. I might wake up and want to be Asian, or I might make up want to be a boy and be a girl. I thought that was disgusting. I really did. And I was done with his line of questioning. He says modern leftist sensibilities about just waking up and picking that you want to be a gender. And I wrote, Ted Cruz at this point needs the Grammy Award for his rendition of Pennywise, because that was ridiculous. Y'all, you don't have to agree with people who maybe don't align, who are gender non-binary. You don't have to agree with people who maybe are racially non-binary. Maybe they change every day. I don't have to agree with anything. But the fact of the matter is that there are people in this world who don't live like you live. Nice people, tax-paying people, perhaps even religious people, people of faith, Christians or other faiths, people who have children, people who do a lot in the community, people who are very gifted by way of scientifical whatever, very gifted mathematically, people who don't necessarily live like I live, people who may choose that the gender they were given at, or the sex or gender that they were assigned at birth doesn't match up to who they are on Monday, Tuesday, Wednesday, or Thursday. If that person is not harming anybody, that's no one's business. And if you're a real Christian, you understand that the Bible says be nice to people. The Bible says love thy neighbor. And who is your neighbor? Well, everybody's your neighbor, to be quite honest with you. And what is love? It's being patient. It's being kind to people. It's not being boastful. It's having a little bit of understanding with people. Now, does that mean that you have to interact in your just private life with people that you don't agree with? No, you may not, in your home. No, you don't have to welcome everybody in your home, but you go out to society. The fact of the matter is there are people in society, nice people who, honestly, if you weren't sniffing around under their clothes, you wouldn't know what they are. I just didn't like that line of questioning. And he was so loud with it, so just loud and ignorant with it. There's a difference between maybe somebody legitimately opposes gender nonconformity, and they oppose it, but they're willing to learn about it in hopes that maybe they can get to a place where they accept it, or even somebody who opposes it but is still willing to hear the argument about it because they appreciate the fact that not everybody is the same as them. But what he was doing, he wasn't doing that. He was acting Pennywise. It's what he is, clown. Didn't make any sense. So I didn't take that many notes on Ted Cruz because he got on my nerves and I didn't like it. Then Senator Coons, a Democrat from Delaware, he gives his questioning, and he talks about the downward departure in those sentencing guidelines and that it's a policy norm. Basically, he does witness rehab. He didn't really get into anything substantive. Ben Sasse, Republican from Nebraska, speaks, and these are the 20-minute rounds. So again, this was day 3, because he has an interesting exchange on day 4 that we'll get into later. He says that he likes, oh no, this is where he talks about it. Okay, so Ben Sasse, he says that it just concerns him that she doesn't hammer down a judicial philosophy, but he likes that she gives nods to originalism and textualism. He asks about her growth as a judge from year 1 to year 5. He then gets into not really asking her questions, but he says that, a few times his colleagues have brought up cameras in the court, and he says he's opposed to it. He says the court ultimately has to make the decision for themselves, He says, but he thinks the increase in cameras in the Senate and in Congress has contributed to, and this is his words, not me. This is what Ben Sasse said. Ben Sasse, Republican from Nebraska, he said it contributes to jackassery. Now, y'all, I've heard a lot of words. You know, my generation, my people, I love them, but we'll make up a word in a minute. I never heard jackassery. It's now become one of my favorite words. I love it. And you know, he didn't call anybody out by their name, but, and I didn't see this. I was listening to it. I didn't see it, but I read somewhere that Ted Cruz was sitting right next to him when he said it. Now, that was basically all of Ben Sasse's. Ben Sasse has given us jackassery. I want Ben Sasse to be getting an award somewhere. Don't they do like social media awards, or, you know, the best of the West from 2022 or something like that? Jackassery is going to carry me all the way to the new year. I'm telling you right now, jackassery just was, it was what it was. Let me stop saying that. Let me move on, because I'm being petty now. I think I mentioned earlier, Ben Sasse is another representative that I've not seen him act in a way that was unbecoming of his dignity, quite frankly. Senator Blumenthal, Democrat from Connecticut, he speaks, and he just speaks to the historic moment. He talks about voting rights. He talks about activist judges on both sides. And then he gets into more of the, I think I got ahead of myself earlier, but Blumenthal gets into more of an explanation of the shadow docket, the no oral argument, the per curiam opinion, not that many brief. He says since 2017, there's been an increase in those shadow dockets. Now, again, I might not have just, maybe that just wasn't on my radar, or something that either I was ignorant to the term, I was ignorant to the practice, and then the label of the term, or maybe I was ignorant to the fact that this practice was outside of the norm. So I'll just have to do a little bit more research myself on the Supreme Court and the shadow docket. He says that, oh, and then he talks about how Justice Breyer, who Ketanji Brown Jackson had clerked for, one of his favorite cases was a case that involved invalidating school integration, racial integration, I think he means. And it was a majority 5-justice plurality. That means, so if ever someone says it was a majority plurality decision by the Supreme Court, that means that the majority of the justices agreed, but they agreed for different legal reasoning. That happens. They all agree that this side should win, but each of the agreeing justices might have a little bit of a different legal reasoning. That happens because we all have brains. That's the best way I can put it. We all have brains. We all read words. We just all think in different ways. But back to Justice Breyer and this decision. So Justice Breyer wrote a 70-page dissent, and he said he's most proud of this in his career as a justice. Now, that was cute. That was cute. But as a law student, I do not like those long dissents. What are you writing a 70-page dissent for? You lost. You lost. You lost. You can't find a way to parse that down a little bit. I understand about wanting to get your position on record, my man. A 70-page dissent, but as he was explaining it, I was all with him. I was like, oh, that's an interesting thing to look back on, until he said 70-page dissent, and then I had law school flashbacks, and I ain't like it no more. But you have to excuse me sometimes. So then, y'all, if y'all have noise, that is my neighbors. Let me keep going. So then Josh Hawley, the Republican from Missouri, I've heard heard it both ways. Somebody get in the comments and tell me, is it one of those things where you have to be from there? Like you say it Missouri or Missouri? I don't know. It kind of tickles me. You know, Josh Hawley goes on and on about the sentencing, and he just interrupts. But then he does let her respond. I will say he does at least allow her to give a response at some point. So I commend him for that, but I'm not going to stay on that. I'm off of him. Then Senator Hirono, the Democrat from Hawaii, she speaks. And she gives more information about her when she asked the nominees about sexual harassment questions, because she wants to bring it up and have people held accountable. And she thinks she needs to ask both men and women. And again, I think I said in the last video, I think that's fair. I like that she does that. I wish more of them would do that. They asked, I think it was Cory Booker, maybe asked, I want to say Amy Coney Barrett, if she aligned herself with any like white supremacist group, racial groups like that. And I felt that somebody should have asked this. Again, you might think the question is ridiculous to ask a certain person, but the fact of the matter is the fairness and the equity is in the fact that we're asking everybody the question. If everybody should get asked the question. Now you can say, oh, of course not. That's fine. But it's a question. So I felt like they all should kind of be asked those questions if that's the tradition we're going. Or in the alternative, if we're not going to ask those questions, then we don't need to ask anybody those questions. So then there's a long exchange about the discrepancy in the information about, you know, not getting the probation something or another that the White House got after Josh Hawley's had his questions. And, you know, they go into that again. I mentioned in my last video that was sloppy. I'm sorry, that was sloppy. At the point, I understand somewhat that once we got into the questioning of sentencing and she kept bringing up the probation officer recommendations, I understand that at that point, when we didn't have that in the record, the White House said, okay, well, we need to get that in the record. I understand that to a point, because maybe they didn't know that she was going to bring up the probation recommendations. But at the point when they got the probation records, I personally, I'm a little bit old school. I'm a little bit country, a little bit backwoods. Somebody should have came down and in front of everybody said, hey, just so y'all know, we got this information, since it keeps coming up. Now, Dick Durbin says, you know, everybody got it. It was just handed out to staff. But that looks bad. I don't care. I understand maybe it wasn't ill intent, but the way it was done looks bad. That's just the truth. Sometimes you have to admit that. Then, let me see, because this was a long exchange. So then they start asking for the pre-sentencing reports. Pre-sentencing reports are, and I think they're in criminal cases. I'm not a criminal attorney, so I wouldn't know best how to characterize these, but it's basically a wealth of information, victim statements, very detailed information, interviewing people, that goes into what the judge can consider. It compartmentalizes a lot of information for the judge to consider at the second stage. Someone is accused, someone is found guilty, and then there's a second process for sentencing. These are nearly always under seal. They're presumed confidential. They are presumed to be sealed. Sealed means closed, you know, closed to the public. And now they want to get those. And Dick Durbin just basically says that's dangerous and unnecessary, and we've never done that before. And it's not okay. And my issue is, not all judges come from academia. Not all attorneys and stuff like that come from academia. She comes from private practice. So it's not that she has a unique record of cases. It's just that she has a set of cases that y'all aren't used to seeing. And because not everybody works in the cloud of academia, these are about real people. The people know that these are presumptively sealed. And so they're very honest when they go to do these interviews for this pre-sentencing report. And no, no, you don't need this. And so now people that come from regular practice can't be justices. Like, I just feel like the showboatery and jackassery, as Ben Sass says, was just really, I'm not staying on that too much. It was ridiculous. So Senator Cotton talks, Republican from Arkansas. He does the same thing, crime, sentencing, you're soft on crime. You represent Gitmo detainees. Mind you, we do have a Sixth Amendment right to counsel for everybody that comes in our court. That's not my fault. That's in the Constitution. Originalist, textualist, strict adherence to the Constitution. It's in the Constitution. So I didn't spend too much time on him. It irritated me. I moved on. So then Cory Booker talks, and I'm going to have to post this somewhere. He basically just he doesn't ask questions. All he does is go over the historic moment, and he calls some of his colleagues performance artists, stunt queen. He basically said stunt queen. And he talks about the history and the plight and the underrepresentation of particularly African Americans in this country, and how decades ago, Ketanji Brown Jackson's marriage was illegal. She's in an interracial marriage, and the Virginia v. Loving case had to make that marriage legal, had to give people a right to marry who they want to marry, regardless of how they look. And it was just a very moving moment, I think, for both sides, actually, because someone else mentions it, that it was pretty moving, and he basically says, God's got you. And in my mind, he stood up for her in that moment. Now, y'all can say that it was inappropriate or whatever, but I remember during Amy Coney Barrett's confirmation hearing, they kept hammering her on her religion. And if the Republicans had to, after each time, say, you're allowed to be religious, and that's not going to come in to her decision. So it happens on both sides. But he didn't ask questions. Cory Booker even told her, Democrat from New Jersey, he told her, he said, sit back and relax. I don't have questions. I'm just going to talk. So then Kennedy, Republican from Louisiana, speaks. And I wrote down, he's the head gaslighter in charge. Again, he is so tickled and enamored by the statement, stay in your lane. Like he's never heard it before. And I just feel like that if he's never heard in conversation where people say, stay in your lane, that he's out of touch with life. I'm sorry. He's out of touch. Y'all, I'm from Louisiana. You can go up to all types of people, all types of socioeconomic backgrounds, all types of demographic. And in conversation, if I'm talking to somebody and I say, I think this person needs to stay in their lane, they're going to know what I'm talking about. There's not many. I'm sorry. I don't believe it. Whatever. I don't believe it. I just think it's a problem that he is so tickled and enamored by stay in your lane. Like he's never heard that before. It's a problem to me. You're out of touch with society. I don't care how much money you have or how many connections you have. If you are that out of touch with just general society, then you're not representing anybody but yourself. And he gets on my nerves because I think he is a gaslighter. What does he talk about? States' rights and talking about people don't like states' rights. They can move, and reading new rights into the Constitution. And I don't know. I didn't stay on him that much. He stay in your lane. Like he's never heard that before. If he hadn't heard that before, he shouldn't be in representative government because he doesn't represent anybody. He's not a representation of society. Then Senator Padilla, the Democratic senator from California, speaks. he talks about immigration and the objections to using the word alien. It's more, I don't want to say politically correct, because it's not always about politically correctness. In society, as we grow and as we recognize more people as being, I don't know, worthy of peoplehood, we change our language. It's happened all over time. You know, there were words that wives and women were called that they are not called anymore in polite society. So it's more socially acceptable and polite to say illegal immigrant rather than alien or illegal alien. I prefer the term foreign national is the term I use, but I guess I see in the immigration context it's better illegal immigrant. But he appreciates that, I guess, in Ketanji Brown Jackson's writing, she uses illegal immigrant rather than alien. You know, he calls out some people. And then he talks about it would be a shame if Ketanji Brown Jackson doesn't get bipartisan support. That was all well and good, but I remember that Amy Coney Barrett was darn near a party line. It wasn't that many Democrats that supported her because they didn't like, you know, how it went about. So I felt like that was one of those moments like, hey, baby, if I was you, I would get away from that. Like, that wasn't, again, the hypocrisy. You don't see it when it's your side doing it. Amy Coney Barrett wasn't confirmed by a whole bunch of people. It was pretty much, it was kind of a party line confirmation. Maybe a few Democrats joined in. So I tuned him out too. It's ridiculous. Tom Tillis from the Republican from North Carolina speaks. He doesn't take up his whole time. He yields back his time, a good bit of his time. He talks about intellectual property, which is a particular interest to him. I'm sure he just wanted to get that on record, on camera, and it happens. He talks about digital criminal enterprises, like maybe viruses and, you know, obtaining digital identity theft, things like that. And I think he was talking about something. It sounded like he said that he had grandchildren, and then he also had his own 2-year-old. Like, he has grandchildren, and then himself has a 2-year-old that's not a grandchild, but that it's his child. And I didn't know about that. You know, Tom Tillis is not young. I always wonder about people who have grown kids. They did their job. Their kids got out the house. They're on to their own family. And then they have little bitty ones behind them. They start all over. But that is not about politics. That's just something it stumped me. But Tom Tillis was respectful. He didn't use up all his time. I think he felt like remember, Tom Tillis was one of the ones that finished his 30-minute sessions earlier in the day. So I'm sure he felt like he said all he needed to say. Then Senator Ossoff, the Democrat from Georgia, spoke. And Tom Tillis did compliment Ketanji Brown Jackson and said that she had poise and grace and judicial temperament. And so Ossoff, who's speaking, who I'm talking about now, he echoed Tom Tillis's compliments. It seems like they might be friends, like how Cruz and Booker are friends, because they compliment each other a lot. I like to see it. I like to see just you know, some of those senators you would have to Photoshop common decency on. And it's a shame. I like to see a little bit of the pleasantries and the politeness. I like to see that we can act like we have some sense, because in my opinion, what marks us as the country on the hill and what is a true testament to American exceptionalism is how our court system operates, is how our political system operates, is the fact that we have supposedly peaceful transitions of power, is the fact that we have an adversarial system in government, is the fact that I could have a best friend who is on the completely opposite end of the political spectrum as me and still support that person's right to voice their opinions, their right to have their opinions, their right to learn about everything possible that could get them to one side of the spectrum and me to the one side of the spectrum. And to me, that is a large part of what makes us the country on the hill, as I like to say. But also he yielded his power back too, and he's another one that had to finish his 30-minute session at the beginning of this day. Talks about, the Establishment Clause, free exercise of religion, speech. He talks about defamation as it regards to public figures. I'm going to have to do a blog post on my website, www.nrevlawg.com. I'm going to have to do a blog post about defamation. It's been coming up in pop culture, politics so frequently, and it's one of those words that's used broadly that has a lot of legal components and elements, if you were to take a defamation suit in court, but I'll have to get to that. He talks about war powers and things, and someone mentions that, Senator Blackburn speaks next, and she mentions that Ossoff is a new dad and that he can show them pictures. I wanted to see the pictures. Don't just say he a new dad. I want to see the picture. I want to see the baby. But so he yields back time, and then Senator Blackburn, y'all know I had Karen in charge. She speaks. Her main concern was abortion, the child sentencing, gun rights, why the Second Amendment can be subject to license requirement, but abortion isn't, and releasing criminals. I didn't focus on the substantive of what she was talking about, but she did compliment Ketanji Brown Jackson. She said a lot of her constituents did tell her that they thought Ketanji Brown Jackson had an excellent temperament. So that ended the day 3 20-minute rounds. I'm going to put a time break here. This now starts day 4. Day 4 was witness testimony, and I'm going to try to breeze through this. But day 4 was all the witnesses who come in support and in not support of the nominee. So we start off with an ABA panel. Wait. We start off with Dick Durbin, who introduces what's going on. Who's here? What are we doing today? It's day 4. This is the final day of the hearing, I think. He gives big compliments to Senator Grassley, the Republican, and he says he's always been honest and fair. They've done these hearings a lot of times together. They're both ranking members, and he just really ups, big ups to Grassley. I don't think I've heard anybody say not nice stuff about Senator Grassley. Senator Grassley is one of the older senators. He's been there a while. That's why he's a ranking member, because of seniority. I don't think I've heard many people say anything less than kind about him. And I'm thinking, I don't think he goes on TV doing stunts and shows a lot either. And that might be just a sign of the times with age. Maybe he's not interested in all that, but that's just my recollection. So Senator Tillis, the Republican from North Carolina, makes a joke, and he says, well, it was kind of true, but it was kind of a joke. He said, well, 62 years ago today is when Senator Grassley started his political career. And then he gonna say, I think he was arguing Iowa statehood back then. It was a joke. It was funny. They jonesed about it. Then Dick Durbin, he says he want to thank everybody who was behaved, in particular Ben Sass, in that jackassery comment. Y'all, I think I never heard anybody say jackassery. I just think that tickled me. That was one for the books. And then he compliments Cory Booker for bringing down the House with his speech. I'm gonna post that somewhere. That was a moment. That was a moment for me, anyway. Grassley didn't have any remarks. We start with the ABA panel because the ABA gave her one of the highest ratings, and then the question set is, they say basically, Senator Cornyn, the Republican, he kind of sums up what the, I guess, right side issue with this ABA panel. He talks about the ABA's political positions and how their literature tends to have a certain lean. I think he interprets it as having a left leaning. That's fair to bring up. But it is also fair to bring up that the Federalist has a lean too. So this is what I will say about the ABA. When it comes to the Federalist definitely has an agenda. Most of the time, if you're an attorney in practice and you pay to be a part of the Federalist, you subscribe to their, I think I call them principles, because I don't want to say ideology, because I think ideology has a negative connotation, and I'm not trying to be negative about it. That's just their principles as an organization. So that's the Federalist. The ABA is slightly different in that, and I need to up my ABA membership now that I think about it. Y'all, it's expensive to be a professional sometimes. Most all attorneys do maintain an ABA membership because the ABA is the agency that accreditates our schools. All law schools are ABA accredited. They sanction our bar exam, many things that the ABA just does because the legal profession is a self-regulating profession. So you will have a lot of attorneys who are ABA members and who will tell you, I don't necessarily agree with all their stuff because the ABA might have a slant. The little bit of a difference is I think the ABA has a slant depending on the composition of the board, or they hire writers who write articles. If you're an ABA member, you have a whole bunch of articles, very informative articles that you have access to. So they hire writers and things for this. So the writers might be left-leaning. Now, I don't know if that's y'all are hiring left-leaning writers or if it's left-leaning attorney writers who are applying. I don't know. But I think it's fair to say there's a lean, but if we're calling out liens, let's call it out on both sides and let's examine the lien. Because if the ABA gets a different board and maybe more writers apply, maybe from a different position, the ABA will switch their leanings. But the Federalist Society is not going to switch their leanings because that's just what they are. So I thought it was fair to point it out, but we need to point out everybody, and we need to be fair and judicious when we talk about it's really hard to find just a neutral. I think I was thinking about this, and I was in my mind, I said, if Jesus came back, Jesus would be neutral. And then I had to correct myself. No, Jesus wouldn't be neutral. He would be right. That's not neutral. It would be his way, because that's what it is. So, but, just for demonstration purposes, nobody's a saint. So, whatever. So, Cornyn does the majority of the back and forth with the ABA in this. And then he says, well, they don't have access to the pre-sentencing reports. Again, nobody has access to that. They're not. Senator Klobuchar asked a few questions. She asked if Ketanji Brown Jackson, if her ruling was anything outside of the judicial norm that they saw. And they said it wasn't. They said, and then one of the ABA representatives points out that it was 3 different people on this ABA panel. And the reason I'm calling it an ABA panel, because each of them were representative of different, like an ABA standing committee, ABA as a whole, ABA this. And I don't know if they think that, oh, but we're all separate. Y'all, let's not front. Whatever. The ABA panel is what I'm calling. But Senator Klobuchar asked about her reverse cases. And one of the representatives says that most of her reverse cases were novel areas of the law. I know it's hard to believe, but sometimes issues come up in legal disputes that are novel. Novel meaning they're a case of first impression. They haven't been dealt with. They haven't been dealt with either in that locale, in that jurisdiction, or just generally they haven't been dealt with. And so the judges having to create a new logical reasoning behind it. But that representative says all her decisions, the reasoning was sound. So here's what it is. So the ABA panel was friendly. Then the second panel comes, and I think first I'm going to try to, this was short, because they only get 5-minute questions. I'm going to go through who all was on the panel in general. So you have one of the leaders of the Congressional Black Caucus. You have and she was approved, she supported Ketanji Brown Jackson's nomination. You had the Alabama Attorney General. He was a Republican. He thinks she's soft on crime. He opposes Ketanji Brown Jackson's nomination. You have a professor at the University of Virginia Law School. She's known Ketanji Brown Jackson professionally for a while. She approved or she supported the nomination. You have a former law clerk to Brett Kavanaugh and currently a professor at George Mason's Antonin Scalia Law School. She discusses federalism and the importance of textualism and originalism, and basically she don't really, I don't know if she was, I wouldn't go so far as to say she opposed, but it wouldn't have been her pick. I think that's I'm going to give her that. It wouldn't have been her pick, is what I'll say. You have the leader of the Conference on Civil Rights. They support. You have a woman named Eleanor McCullen. She is an anti-abortion activist. She's a older lady. I'm not saying that to age shame her. I'm just saying that to say this was a diverse panel of generations. And so I think I mentioned in my last video, I do think the multi-generational approach to all issues are important because different generations have stories that we don't have, and then we might have something they don't have. And I think everything should be a mix of all of it. I think the more diverse the human ecosystem is, the better. But she's there mainly to talk about that free speech buffer zone case. She didn't say she was opposed to Ketanji Brown Jackson. She said she was she was kind of opposed. And then I had to take a break to before they even get into it, I advocate for buffer zones for both sides. I do think that people get out of pocket. I just do. It's not so much as about your speech. It's not so much as about your viewpoint, but it's about your behavior and if it's threatening. And anybody who's going to have any medical procedure, whether you agree or disagree, should not be harassed all the way up into the door. I'm a fan of buffer zones. Now, I know that on both sides, they get ignorant. And you can have a buffer zone so large that it does diminish the right to protest completely. That I don't agree with. But what I don't understand about these buffer zones, this is my example. For the right to be saying, oh, you shouldn't have buffer zones as it relates to when we protest about pro-life. Okay, then I can bet you that if the LGBTQ plus community were to start protesting on everybody's church, I mean, just on the church, you walking in thinking, you about to get your praise on, and they right up in your face protesting and yah. I bet you'd want a buffer zone then. But the church is probably private property, which I'm not understanding. Are these clinics not private property? What are we doing here? Same thing. What if all these child victims, since we so concerned about the children, it's about the kids, it's about the children. What if they start protesting on the Catholic cathedral steps? You want buffer zones then. But again, I'm pretty sure that's private property. So what I'm not understanding, and I'll just have to do more research because this is my own ignorance. If it's private property, all that is private property, I can tell you to get off of what I want to tell you to get off of. It's private property. Point, full stop, period. Private property, the owner tells you to get off, you got to go. It's particularly if you live in a stand your ground state, you got to go. If it's public property, then public being controlled by the government in some way, then the government can set limits on time, place, and manner. Now, those limits can't be so egregious to where you completely rule out speech, but there should be limits. I just think that society nowadays, people have gotten out of pocket. And so to an extent, to a reasonable extent, yeah, I have no problem with buffer zones. No, since you act like you don't know how to just pick it, how to just stand there. When I looked at the pictures of the suffragette movement, those women just stood with their banners. They weren't even saying anything. Now, granted, they got arrested and treated terribly, but they were just standing there. Nowadays, people don't do that. Nowadays, people do act out. I'm gonna get off of that. So then the next person is Richard Rosenthal. He's an appellate attorney, and he's been friends with Ketanji Brown Jackson for 38 years. They've been friends. I think he said he was 12 and she was 14, and he really went on and on about her. He said he's about to get married soon, and I felt like, man, your fiance gonna get jealous, but you can tell that this is his friend. I mean, he talked about her accomplishments in high school, and she was voted most likely to succeed, and she got accepted into Harvard. And he said nobody was surprised because it was Ketanji. We just knew she can do it all. And he said she was trying to help everybody, and he really went on, but he was in support of her. Then you have a lady from a group called First Liberty named Keisha Ross, and she is opposed to the nomination. And she talks about how she doesn't want, CRT, critical race theory, has no place in the judicial system. And even though there are racists and racism is alive, but that doesn't influence people's outcomes in their lives and things like that. She was opposed. Then you have the captain of NOBLE, which is the National Organization for Black Law Enforcement Executives. I think I got that right, that acronym right. He's in support. Then you have Operation Underground Railroad, which you had their chief legal officer speaking. And this is an organization that deals with the sex trafficking and child abuse and things like that. And she's opposed because of the criminal sentencing. She brings up a term that I'm going to start using called, no, maybe not, because I can't explain it. Anyways, that's the introduction of this panel. So then these are 5-minute question rounds. Not all senators participate in the 5-minute questions. And I think each side has different rules about who gets to go next. I think it sounded to me like the Democrats still went by seniority regarding the senators who were there who wanted to ask their 5-minute rounds. And then the Republicans went by maybe first come, first to sign up for something like that for the people that wanted to be there to ask their rounds. So Durbin starts, and he asks, would Noble support somebody who's anti-police and soft on crime and this and that and the third? They say no. And he assumes that the Fraternal Order of the Police wouldn't do the same. Grassley speaks. He gives a few mentions to the soft on crime stuff. I don't think that's soft on crime, y'all. There's a difference between being soft on crime. Soft on crime to me is when you do something that really doesn't have any logic other than you're being soft on crime. And what she was doing wasn't that. So, I just think it's a difference. Then we have Senator Whitehouse speaks, and he spends the majority of his time grilling. I mean, absolutely going in and in on the Alabama Attorney General. He didn't even ask about the nomination. He just spent his time saying, did you support these groups that were signing off to delegitimize the presidency? And did you support this? Did you support that? Did you support all this other stuff? That's all he spent his time on. And he was hammering the Alabama Attorney General. And he asked him repeatedly, do you believe President Biden is the duly elected president? And the man said he's the president. And he said, do you believe that he's the duly elected? Then the man tried to get back with him. Senator Whitehouse said, no, I'm asking the questions here. The man just kept saying Joe Biden is the president. And he asked him, are you purposefully admitting duly elected? And the man just said he's the president. Then Senator Whitehouse went on about his business. Y'all, that is a big issue. While we want to talk about soft on crime and this and that, let's talk about it all. Mention it all. Shout out to Bethany Frankel. Mention it all. Let's talk about all of it. Then Senator Corn speaks. He talks about Obergefell and reading stuff in the law. Senator Klobuchar talks. She mentions the qualifications again. Tom Tillis, Tom Tillis talks about the sidewalk counselor. That's what the Eleanor McCullen, the anti-abortion lady, that's what she described herself as. And she says that she was there and they weren't aggressive and in your face and noisy. And she says that if they were doing that, she said that's not right. And the reason I mentioned her age earlier, considering her age, I believe her. I believe her. Because at first, my natural inclination was to say, just because you weren't being noisy and in your face doesn't mean that other people were. But considering her age, and she was very matter of fact in saying, if people's behavior was crossing into the bounds of being noisy in your face and harassing, that's not right. I believe her. I'm gonna give her the benefit of the doubt on that because of her age. She's not a politician necessarily. She's an activist, but I haven't heard nothing about her. So she's not one of the ones that's always on TV doing stuff. Then Senator Blumenthal speaks about the historic achievement. He takes his time to talk a little bit more about voting rights. Senator Blackburn speaks. She sticks with Eleanor McCullen about the anti-abortion. Then she asks another panelist about the CRT. Now, I remember Ketanji Brown Jackson saying that she's heard of CRT, she's studied it, but that doesn't come into her judicial methodology or philosophy. But whatever. She brings up the pre-sentencing reports. Dick Durbin again says that he is not inclined to release those reports. They have an exchange with Senator Coons and why we can't get them, and even in closed session and this and that. Y'all, these are so third-party heavy. It's not just about the judge, the plaintiff, and I mean, it's very third-party heavy. No, they shouldn't do it. No, it should stay where it's at. These are sealed for a reason. They're presumptively sealed. There's not many areas in the law that we presume something, but these are presumptively sealed. So, no, he wasn't inclined to release those things. So then Cory Booker speaks in this exchange, and he reiterates, he says, in speaking with his friends who are actually in practice, they tell him, like, no, you can't redact these. These aren't even, these aren't the types of things that you can even redact, because to redact it would be, you just wouldn't have anything. So that exchange was very important. So then, let's see. Senator Coons speaks, and he asks, is it him that asks a very pointed question? He asked the professor from GMU, does Ketanji Brown Jackson stay in her lane as a judge? And she said, yeah, she stays in her lane. And then that same GMU, George Mason University professor, says that even within conservatism and textualism, there's been cases where Scalia and Thomas, one you know, wrote an opinion and one wrote a dissent, both based on originalism. So, you know, it happens. He lets the Democratic Congressional Black Caucus leader talk about her experience at a HBCU. Then Ted Cruz talks. The sentencing and make the road case, and he knows good and well, Ted Cruz was an attorney. He knows good and well that that case was about procedure and not into the merits. I let him go. Cory Booker speaks for his 5 minutes, and he says that he appreciates the give and take. You know, he gives a nod to he likes it. He says that there's been candidates in the past that he was strongly opposed to, and then he had like professors that he greatly respects come and say, no, we support this person. No, let me tell you why. So he likes the process for the most part. Let's see. And then he lets the representative from Noble speak. And Noble says he doesn't get into politics. He says there's 8 other justices on the court that she's going to confer with. And he says America will be fine. You know, he doesn't get into all the skies falling either. Josh Hawley talks. He talks about the sentencing. We've heard it ad nauseum. I'm done. Senator Hirono asked a few questions. She asked about the importance of female representation. That was her main point. Then she asked the professor from University of Virginia Law School, the former Kavanaugh clerk. She asked her, do you think all the justices need to have the same philosophy? And she said, no, I personally, I don't necessarily think they need to have the same. Okay, then, point blank and period. Then stop getting up here saying we don't like her because she's not an originalist. They cannot all have the same philosophy. I just don't know in what world we live in where I'm off of that. Then Senator, because this video has gotten long enough as it is. Then Senator Padilla speaks. He mainly just compliments Ketanji Brown Jackson, and he says, what would it mean to the country if someone as qualified as Ketanji Brown Jackson can't get bipartisan support? All of them were qualified. Amy Coney Barrett was qualified. And like I mentioned earlier, I don't think it wasn't that many Democrats that joined her. It was like 3. It wasn't that many, I think. I'll have to look it up. Maybe I'm wrong, but I just feel like that was one of those hypocrisy moments. Look, they're all qualified. They're all qualified when they've gotten to that point. So it is what it is. And the Congressional Black Caucus said she checks all the qualification boxes when it comes to her qualifications, you know. Then they end. It was real short. Dick Durbin closes. The hearing the confirmation hearing part is adjourned on this day 4. And he just gives another shout out to Grassley, and again, you know, thanks to Capitol Police and everybody who was in attendance. And that was the end. So that was day 3 and 4, the last days of the confirmation hearing for Supreme Court nominee to the Supreme Court, Judge Ketanji Brown Jackson. You know, remember to check out my website. I'll post more stuff, www.nravblog with a B as in boiler, BLAWG.com. I'll be back to you with more recap and reviews on things that happen on the Hill. Until next time, stay informed.